Okay, good morning, everyone. Welcome to the Judiciary Committee hearing this Friday morning. My name is Carl Rhodes. I'm chair of that committee. This Zoom meeting and YouTube live stream event will include the following agenda. We only have one today, that one that was supposed to have started at 9:15, but due to technical difficulties, it has been delayed for a couple of minutes. The other members of the committee are Vice Chair Jared K.O. Kalole, Senator Laura Ocasio, Senator Mike Gabbard, Senator Chris Lee, Senator Donna Mercado Kim, and Senator Kirk Favela. This meeting, including the audio and video of remote participants, is being streamed live on YouTube. You will find links to viewing options for all Senate meetings on the live and on-demand video page of the legislature's website. In the unlikely event that we have to abruptly end this hearing due to major technical difficulties, the committee will reconvene to discuss any outstanding business on Wednesday, February 17th at 9 a.m. Again, that's Wednesday, February 17th at 9 a.m. And a public notice will be posted on the website, and that will be a video conference meeting as well if we have to. For the people testifying remotely, all testifier audio will be muted and video displayed and video disabled until it is your turn to testify. There is a 2-minute time limit per testifier. And there's a little clock that you can watch to see if when your time is about to run out. If there are temporary technical glitches during your turn to testify, we may have to move on to the next person due to time constraints, but we appreciate your understanding and remind you that the committee has already received your written testimony, and we'll try to come back to you. We'll try to make it work out, but if we can't, I apologize. I'll be reading a list of people who testified in most cases. I apologize if the closed captioning doesn't accurately describe the names. If you're interested in reviewing the written testimony, please go to the legislature's website, www.capitol.hawaii.gov. You'll find a link to testimony on the status page for the measure you're interested in. And I believe that's all the introductory remarks. First bill today is SB 630 relating to child support enforcement, and establishes that every judgment for child support is enforceable until paid in full. First up on SB 630 is Brandon Flores, Deputy Attorney General, with comments. Leah in support, and Kelly Polly also in support. None of them signed up for in-person testimony, so we'll go ahead and move on to the second bill, which is SB 639. SB 639, hang on a second, prohibits courts of appeal from affirming, modifying, reversing, or vacating a matter on grounds other than those raised by the parties to the proceeding, unless the parties are provided the opportunity to brief the court and present oral arguments on the matter. First up on SB 639 is Elizabeth Zach, Supreme Court Staff Attorney.
Hi, Senator. They're not present. Oh,
they're not present. Okay. They're in opposition. Leah in support. Robin Chun, Deputy Attorney General, with comments. Since there's no one to ask questions of, we'll go ahead and move on to the next bill, which is SB 714. SB 714 is relating to publicity rights. It clarifies that the rights of publicity include the rights of individuals who died prior to the enactment of the Hawaii Publicity Rights Act. First up on SB 714 is Jesse Rivera.
Hi, Senator. They're not present.
In support, William Meyer III. Oh, there you are. Go ahead. You have to unmute, though.
Thank you. Chair, Vice Chair, members of the committee, aloha and good morning. My name is Bill Meyer. I have practiced business law in Honolulu for over 4 decades. My specialty is intellectual property and entertainment law. In the course of my career, I've had the opportunity and the honor to assist many of Hawaii's most iconic recording and other artists, as well as their heirs, in connection with their business and intellectual property matters. I strongly support SB 714. It confirms the legislative intent that Hawaii's postmortem right of publicity law applies to persons who died before July 15, 2009, which was the effective date of the act, as long as those persons are within the 70-year term of protection provided under the act. Why is this bill necessary? Well, recently, the Honorable Alan C.K. ruled that the legislature had not sufficiently articulated its intent that the law should in fact apply to persons who died prior to July 15, 2009. My written testimony contains citation to the law. In a nutshell, the judge found that there was language in the statute and the legislative history suggesting prospective application, but there was similarly language that suggested retroactive application and therefore concluded the law was ambiguous. And under Hawaii law, a statute can be applied retrospectively as long as the legislative intent is clear. As explained in my more detail in my written testimony, this Hawaii law has suffered the same fate as similar laws in other states. All we're asking today is that this legislature employ the same fix that these other states have employed to rectify the situation.
Okay. Thank you. That's the 2 minutes. If you can hang around for a few minutes, I at least have questions and other members may as well.
Very well.
Thank you. Next up is Eric Kaleolani Keave.
Hi, Senator. They're not present.
Not present. He supports as well. Mauricia Palma Elmore in support. Eric Gilliam in support. Mario Collins in support. Kanoe Casimiro in support. Robert Kapanui in support. Michael Ruff in support. Rosalind Katrachia in support. Kahai Olelo Morales in support. Amy Hanai Ali'i Gilliam for the Hawaii Academy of Recording Artists in support. Seth Reese in support. And that's all the testimony we have on SB 714. Members, questions? If not, I have, oh, I'm sorry. Go ahead, Senator Kim.
Yeah, just a quick question. So if in fact this bill passes, will the families of those who are deceased and being exploited, is there some kind of compensation? Is there some kind of ramifications, or what would happen?
The statute as passed, it's actually patterned very closely against the U.S. Copyright Act. The enforcement provisions include the ability to seek injunctive relief and to seek statutory damages and to disgorge the profits that people who have misappropriated someone's identity have made in connection with that misappropriation. So there are remedies that the statute specifically provides.
Okay, so they'd have to go to court and prove that in order to, so this bill just enables that.
That's correct. What the bill does is the bill recognizes the existence of this thing called a postmortem right of publicity. And there's technical language that has to be used to make it clear that it is the legislature's intent that the bill apply to people that died prior to the act. And like I said, at least 4 other states encountered the same problem, and they fixed it by employing the type of language that we've suggested. But let me point out one thing.
Thank you very much.
Hang on.
Okay.
Members, any other questions? Okay, I have several. You were going to point out one thing. Go ahead.
Well, I was just going to point out that just as a for example, the people who are now, or the heirs of the following individuals, have absolutely no protection under the law. So Auntie Genoa Keave, no protection. Don Ho, no protection. Kui Lee, no protection. Israel Kamakaviva Oli, no protection.
We read your testimony.
Okay, very well.
So regarding the retroactive nature of the bill and its application to the persona of individuals who passed away prior to the act's existence in 2009, are there circumstances where the act would not apply? Yes. Yes, there are a number of exceptions that were built into the bill to be sensitive to. Not this bill, but the original act. Yeah, the original act. The original act did provide a number of exceptions. I can get you the sections, but in any event, they accommodate First Amendment considerations
and common sense considerations. For example, if a recording artist or an actor consented to appear in a motion picture or sit down for a recording session, there is an implied understanding that that person has granted the record company the right to identify who the artist is on the recording. Any other result would be absolutely absurd, because it would mean that a record company could only state, this is a recording of a very famous human being. So one of the exceptions that was built into the statute to protect the recording industry was that if an individual has voluntarily participated in the recording.
Let me give you a specific situation. So
Sure.
If the estate of someone who had died, and that's redundant, I guess. If the estate of someone said, was approached by someone who said, you know what, we don't have to give you any money for this, but we'll give you, $20 to use your deceased relatives' likeness and publicity. And they said, okay, well, $0 or $20, I'll take the $20. Does this bill, or I guess it's this bill, would this bill make it so that they can break that contract and say, you know what, I don't accept that deal anymore because we now have rights?
Not exactly, no. If somebody has agreed to, you're talking about after the fact that the recording has been made. I'm not quite sure on your fact pattern. As long as there's been under the statute, exception 4 provides that if you voluntarily participate, that will be considered consent.
No, what I'm talking about is a situation where the individual who's making the offer knows that they don't have to give the person anything because the court has ruled that it's prospective. So the estate says, okay, since we're not going to get anything, we'll take your pathetically low offer because it's better than nothing. Will this bill undo that? Will the estate be able to say, hey, you know what, we don't accept that deal anymore, we're going to go back on it?
Well, if there was such an agreement, a court might interpret that as a permission.
Okay, so it might hold up. The contract might hold up. Okay. So would enacting this bill resolve issues about the use of an individual's persona, even if they predeceased the act's enactment, or will it result in more litigation?
Well, that's the whole point of this, is to clarify that it does apply to people who died before. It's important for you to understand, if you're a plaintiff, if you're the heir of someone, you can't go back 100 years and seek relief for that. As provided in the Copyright Act, if there's a continuing infringement, each new act of infringement gives a new cause of action. But it is subject to a statute of limitations. So in this case, the general statute of limitations would apply. So you could only look back 6 years. And that's consistent with how the copyright law works. If there's been ongoing infringements for a number of years, you become aware of the infringement, you can't go all the way back to the beginning of time and sue. You can only go back for the copyright statute of limitations period, which is 3 years.
Okay. Your testimony refers to 3 other states that have similar laws and have had to make amendments similar to those proposed in the bill before us. What about the other 46 states? Do they have publicity rights, or did they just get it right the first time?
Many got it right the first time. And, it's a real patchwork of, since this is being done at the state level, there's been some talk about getting a federal law so that the law is uniform across all states. But I believe 38 states now have, either by common law or by statute, a postmortem right of publicity law.
Okay. Okay, thank you. Members, any other questions? All right, thanks, Mr. Meyer. Thanks for being here.
Thank you.
We will move on to SB 834 relating to childlike sex dolls. This establishes a felony offense of importation, sale, or possession of a childlike sex doll. First up on SB 834 is Randall Platt for Honolulu Police Department. Good morning.
Good morning, Chair, Vice Chair, and members of the committee. Randall Platt with the Honolulu Police Department. We stand on our written testimony in support of this bill, and I'll be available for any questions.
Thank you. Next is Brendan Ajolo or Ayolo in support. Tracy Ryan with comments. Leah in support. Trisha Nakamatsu, Deputy Prosecuting Attorney, City and County of Honolulu in support. Jessica Munoz for Ho'olanapua in support. Christopher Gellert in support. That's all the testimony we have. Members, questions for, I'm sorry, I didn't see what your rank was. Major?
Captain.
Captain Platt. Let me see if I have any. Because it's not a crime right, excuse me, because it's not a crime right now, do the police departments keep track of, you don't have any way to know how many of these are coming into the state at this point, correct?
Correct.
Okay. All right. Thank you very much for being here. Members, any other questions? Okay, seeing none, we'll go ahead and move on to SB 873 relating to contested cases, authorized contested cases hearings to use interactive conference technology. First up on 873 is William Isla for DHHL.
Chair Rhodes, Vice Chair Kilpole, members of the committee, on behalf of Chairman Isla and the Department of Hawaiian Homelands, we stand on our written testimony and support and happy to answer any questions.
Okay, thank you very much. Next is Daniel Orendenker, Executive Officer for Land Use Commission. Not here, I take it. He had comments. William Hashijo for Hawaii Civil Rights Commission in support. Cheryl B. with comments. Mauna Kea Observatories in support. Juanita Brown Kawamoto for Hawaiian Affairs Caucus of the Democratic Party of Hawaii in opposition. Members, any questions for Director Isla? I'm sorry, not Director Isla. I forgot who I've already, for the DHHL representative. Okay, let me just be sure I don't have any. No, I think I'm okay. Let's go ahead and move on to SB 1034. This expands board and public participation by giving boards the option in conjunction with in-person technology and with in-person meetings to use interactive conference technology to remotely conduct public meetings under the Sunshine Law, even after the emergency even when there's no emergency in effect. First up on 1034 is Alani Kiogig, Licensing Administrator for DCCA Professional and Vocational Licensing.
Senator, they're not present.
Sorry?
Senator, they're not present.
Not present. Okay, with comments. William Hashijo, Hawaii Civil Rights Commission with comments. Daintree Bartoldos, State Council on Developmental Disabilities.
Good morning, Chair. Thank you.
Morning.
Committee members. I'm Daintree Bartoldos, Executive Administrator for Hawaii State Council on Developmental Disabilities. We are in strong support of Senate Bill 1034. I would like to inform you that 61% of our council members are individuals with intellectual and developmental disabilities or their family member. On a national level, these individuals who are in the Medicaid waiver and ICF programs have the highest mortality rate if they should get COVID-19. So we see this measure as an important health and safety measure to our council members. Not everyone is going to be able to get the COVID vaccine. Individuals with intellectual and developmental disabilities do have underlying conditions. So we heard like, once they get the COVID, won't this be over? It won't be for our folks. And so we're in strong support of this measure, and thank you so much for hearing it.
Thank you. Next, we have Shirokakazu Park, Office of Information Practices.
Good morning, Chair. I don't know why I'm not visible, but thank you for the opportunity to testify in strong support of, okay, now they're asking me to start my video. There I am.
There we go.
in strong support of this administration bill. The COVID-19 pandemic forced the implementation of emergency measures that suspended certain requirements of the Hawaii Sunshine Law so as to allow boards to continue to conduct meetings during the pandemic. The silver lining has been that public access and participation were greatly expanded while public health and safety were protected as government transformed nearly overnight and boards were forced to use technology to conduct remote meetings in order to continue doing their work. For greater public access through remote meetings to continue, the Sunshine Law changes proposed in this bill are necessary. Keep in mind that the amendments proposed herein, including that for in-person meetings, are intended to take place when the governor's emergency orders are no longer in effect. In OIP's detailed written testimony, we have explained this bill and addressed the testimony previously provided in the House on House Bill 503, which is substantially similar to Senate Bill 1034, as both were based on OIP's draft proposal. OIP has already provided safeguards in the bill for persons with disabilities. OIP would be opposed to any attempt, whether intentional or inadvertent, that would create a new cause of action for ADA accessibility type of litigation under the Sunshine Law, as those rights are ensured by other state and federal laws administered by other agencies. OIP does not have the jurisdiction or expertise to enforce ADA laws and wants to avoid any conflict in interpretations between those state and federal laws and the Sunshine Law. OIP spent 6 months on different drafts and worked with.
That's the 2 minutes. Thank you very much. We do have your 11 pages of testimony as well.
Okay. Thank you.
Maybe questions, so if you can hang around, that would be great.
I will.
Next is Hakimu Safi for Hawaii Public Housing Authority.
Good morning, Chair, Vice Chair, members of the committee.
Morning.
BHA stands in support of this bill, suggesting amendments. Thank you very much.
Thank you. Next is Kevin Moore for Department of Land and Natural Resources.
Good morning, Chair, Vice Chair, committee members. Kevin Moore, DLNR Land Division. The department will stand on its written testimony and support, and we're available for questions as well. Thank you.
Thank you very much. Next is Luke Sarvis, also for DLNR.
Senator, they're not present.
Okay, he's in support. Derek Mizuno for Hawaii Employer Union Health Benefits Trust Fund.
Hi, Senator, they're not present.
That they had comments. R. Brian Black for Civil Beat Law Center for the Public Interest. Good morning.
Good morning, Chair, Vice Chair, members of the committee. The Law Center with Brian Black, Executive Director, Civil Beat Law Center for the Public Interest. Law Center will stand on its comments and strong support, and just I would note our caution in our written testimony against proposed amendments. Thanks.
Okay, thank you. Next is Sandy Ma for Common Cause, excuse me, Common Cause Hawaii. Good morning.
Good morning, Chair, Vice Chair, members of the committee. We stand in our written comments in support of this bill. Thank you.
Thank you. Next, we have James Gashel, National Federation of the Blind of Hawaii.
Good morning, Mr. Chairman, Vice Chair, members of the committee. I'm James Gashel, testifying for the National Federation of the Blind of Hawaii. Basically, we're going to stand on the written testimony, but I want to highlight the amendment that we suggested in the testimony, which is to add a proviso to the definition of electronic conference technology, and that's section 4 of the bill, to specify that it has to be accessible to and usable by people with disabilities, including blind people who use screen readers. I wouldn't be able to participate in this meeting if it wasn't. The screen readers don't cost anything. The technology that it makes the system compatible with screen readers doesn't cost anything, assuming it's built into the original design. Zoom is, and the legislature uses Zoom. A number of other platforms are not. Cities and counties sometimes use like WebEx, which is not. I'm just going to say that excluding this provision would mean that we would have to make a federal case out of every situation that is not accessible. And we shouldn't have to go to Washington, D.C. for all our remedies. And I'll just say mahalo.
Okay, thank you very much. Next is Peter Fritz.
Thank you, Chair, for the opportunity to test. Can you hear me?
Yes, go ahead.
Okay. While video technology can provide better access for individuals with disabilities, as this chair pointed out, if there are technical difficulties, the meeting will be adjourned and continued at a later time. When I reserve an accommodation such as a sign language interpreter or captioning, it's only available for the length of the scheduled meeting. If the meetings are allowed to be recessed and continued at a later time, I won't have an accommodation and I will be excluded from this meeting. And that is my concern about the way that this bill is written. It used to be that the meeting just terminated. Thank you for the opportunity to testify.
Thank you very much. Let's see. Next, we have Kendra Oishi, Office of the Board of Regents. In support, Deepak Neopane, Executive Director, Hawaii Community Development Authority. In support, Michael Phillips, Vice President, Big Island Press Club. In support, Sterling Morita, Hawaii Chapter, Society of Professional Journalists. In support, Nancy Cook-Lauer, All Hawaii News. In support, Max Otani for Department of Public Safety. In support, Gerard Silva. In opposition, Dr. Jim Sean. In support, Douglas Meller. In support, Playlock Tokuda. In support, Dyson Chi. In support, Lynn Mattisau. In support, Carolyn Kunitake. In support, Michael Galoyo Jr. In support, Edward Hanel Jr. In support, David Anderson. In support, Stacy M. Burke. In support, Larry Meacham. In support, Brandon Young. In support, Kirby Shaw, testifying for the Disability and Communication Access Board, also in support. That's all the testifiers we have on this bill. Any on SB 1034, any questions, members? Okay, let me look down my list here. For Ms. Park, are you still here?
Yes, I am.
Great, thank you. The bill adds a new statute, a new section to Chapter 92 concerning contact tracing at an in-person site when a certain type of emergency has been declared. Is OIP going to be enforcing the contract? Who's going to deal with that? Is that you or is it somebody else?
Well, I guess we would say whatever is reasonable is what we would be enforcing. We only put that in because otherwise the Sunshine Law does not, well, allows people to be anonymous when they testify. Contact tracing, of course, you're going to have to identify who you are, you know, and we put that in just in case something pops up or the emergency orders are struck down, but this this current pandemic or a new type of pandemic arises that causes the board to reasonably want to take public emergency precautions and be able to get back to people who may have attended the in-person meetings and let them know, you know, if anything.
You don't anticipate OIP staff. Do you anticipate OIP staff doing that, or you anticipate turning it over to DOH, or what? How do you see that working?
I think we'll take the complaints. We'll look at it. If it's reasonable, we'll say, okay, that's not a Sunshine Law violation. But on the other hand, we don't do things in a vacuum. We will check and see if there's, and we would still go to DOH and ask them, is this reasonable? You know, I mean, it's not so hard to see what kind of information are they collecting? Are they just collecting the names and addresses or contact information so we can get back to you? And how long are you keeping it? Are you keeping it for, you know, like 2 months or maybe 3 months if necessary, not 3 years? You know, that's not hard to figure out.
But at this point, the way it's written, the contact tracing is optional and at the board's discretion. So
Right.
I guess if it's really an emergency like that, why would it be discretionary?
We're not sure what's going to happen with the governor's emergency orders because you have a lot of legislation out there that would amend those orders. We don't know if they're going to be struck down at some point or
Yeah,
whatever. This is just a precaution. I mean, if you don't want to put it in there, it's not.
No, I'm asking the other way around. If it's important, and you know, we're in a pandemic now, and why would it be optional if it's that important?
Because we think that most times the governor's emergency orders will cover it. But if for some strange reason it isn't covered, you know, this provision provides that additional public safety safeguard.
Okay.
You know, that's all it is.
Okay. Does OIP intend to provide guidelines or adopt rules on how the statute will be implemented?
Yeah, I think we already have with our very detailed testimony that talks about the different nuances, and we intend to provide, you know, guidelines as soon as the bill is finalized or adopted, which hopefully we can do by July 1st. And I'd like to also emphasize too that we're not displacing certain other provisions that are already in the Sunshine Law, because I saw some leaked testimony from DCAB that says we should notify people that they have to board should put on their notice that people with disabilities need to be accommodated. That's already in the Sunshine Law.
Okay.
So
with the contact tracing statute, it's restricted to times when a state of emergency for contagious illnesses has been declared.
Yeah, that's so that they can't just willy-nilly say, we think that we need to get contact tracing information and use that as a ruse, you know, to get people.
But you consulted with DOH about this provision?
No, we did not.
Okay. Members, I'm hogging the questions here. Anybody else want to jump in? Okay. So many boards and agencies have been holding remote meetings by interactive conference technology over this past year. Has OIP been involved in overseeing those meetings?
What we did early on was talk with the boards that wanted to do that, were doing that, and put together some guidelines to help all the other boards conduct remote meetings. You know, I have sat in on a remote meeting or two, but we don't have the staffing to go out and actively watch and monitor all of these meetings.
Has your office received any complaints related to remote meetings? Really? None? Zero?
So I'm not aware of them. I'll go back and check, but I'm not aware of them.
No, it's interesting. I'm glad. That's good. When accessibility issues arise concerning Sunshine Board meetings, such as the instructions on a meeting notice about requesting an auxiliary aid or service, does your office work with DCAB to address them?
Yeah, about the notice, we have requirements that the notice itself say, go to DCAB for these things. We just refer them directly everywhere we can to go to DCAB because they're the ones that enforce that.
Okay. The bill proposes to allow an interactive conference meeting where the communication is lost to continue in audio only mode. What's the rationale for going audio only?
Well, that's in the current law. The current law provides for interactive conference technology, and it has provisions that say, you know, if you cannot, you know, bring back up the visual feed, you can still continue with the audio only. So
would your office object to removing this option so that if an audio visual connection cannot be maintained or reestablished, the meeting is terminated?
You're going to be changing current law, and that applies not just to completely remote meetings, but also to those situations, for example, on the Big Island, where
The reason is that things have changed since OIP passed originally, and the technical capabilities are quite a lot better than they used to be. So the question is, would you object if we said, okay, if you can't have full audio and visual, then it's just I guess a acknowledgement that things are just different than they were when OIP originally passed.
Well, it's not for OIP's, convenience, because we don't even conduct Sunshine Law board meetings.
I understand that.
So
but
I think
it's a policy question.
Yeah, I think you would have to see what the boards would say, because that might require the boards, it would greatly affect the boards. They would not be able to continue. And would this also apply? You're not suggesting that apply to those additional locations, right? Which are not official meeting sites, so that if interactive conference technology is, the connection is lost to those additional locations, they're not going to interfere with the continuance of the official meeting itself, right? Okay. You're not talking about that. You're only talking about the connection between official meeting sites, number one. Is that right?
No, we were thinking of of just having audio only at all, when it doesn't seem like anymore that it's really necessary.
If it's applying only to official meeting sites, that's one thing. I think if you say that it applies to the additional locations, then you're really severely hampering a key provision of this bill and the ability of boards to continue to provide greater public access.
Okay, I think I understand where you're coming from. Members, any other questions on this on 1030, whatever this number is, 1034? Okay, thanks very much, Ms. Park. Thanks for hanging with us. We will move on to the final bill of the agenda, which is SB 301, which would prohibit would ban detachable magazines of over 10 rounds for any firearms, not just for machine pistols, as is currently the case. First up on 301 is John Abbott for Hawaii Firearms Coalition. I see your name. There you are. Morning. Can't hear you though. Need to unmute.
Unmute.
There you go.
There we go. All right. Good morning. How are you? Thank you, Vice Chair and Chair, for the opportunity to provide testimony. We strongly oppose this bill based upon several facts that you see in my testimony. One is that this bill would ban an entire class of firearms, which would be prohibited under the 2008 Heller decision. Secondly, regarding the magazines, there's already 2 lawsuits, one in the Ninth Circuit, one locally, regarding the banning of magazines over 10 rounds for rifles, and also another lawsuit that is seeking to overturn the ban on pistols magazines that are over 10 rounds. I'll be able to any questions. Be happy to answer any questions you have about our testimony. And do you know how many testimonies were submitted in opposition compared to support yet?
Opposed, and it's running about 100 to 1 against.
I'm sorry, I couldn't hear you. You're muted, sir.
Oh, I'm sorry. Shoot. Oh no, I wasn't. Did everybody hear that?
You only got half.
I'm sorry. I don't know what happened. Yes, the testimony is running overwhelmingly against the bill. Over 1,000 testifiers against it, and it's running about 100 to 1 against.
Yes, sir. I counted only 15 in support. I went through the testimonies.
More testimony came in, but it's overwhelmingly opposed. Okay, let's. Next up is Todd Yukutake for Hawaii Firearms Coalition. There you are. Can't hear you yet, though. There you go.
Good morning. Todd Yukutake. I'm just representing myself for my testimony. I strongly oppose SB 301. I'm a retired Army National Guard veteran. And I was on the marksmanship team where I was a competitor and a coach. So I would coach service members. Why this is important is In the military, most service members only shoot their rifles once a year on duty, if that. That's pretty much across all services too. So that's not enough training for service members for a skill that they'll use in a war to save their life or other people's lives. They should at least be doing that 2 or 3 times a year. So that's where my coaching came into play. Basically, service members have to practice off duty with their own rifles or borrow a rifle and practice on their own. And that's what I did on my off duty time. It's a perishable skill, so I just want to stress the importance of that. This bill would adversely affect service members. My other point is I'm also the NRA Hawaii State Training Counselor. I've trained over 100 people in firearms use. I train instructors too. Now, I've trained a large variety of demographics, men, women, children, seniors, the disabled. Some of them cannot use handguns or shotguns for some reason or another. Rifles are easier for most people to use, for whatever reason, competition, self-defense, work. I even taught some government agencies, recreation, hunting, all different types of reasons. So this affects tens of thousands, or maybe even over 100,000 people in the state. Again, owning these rifles is a Second Amendment right. Purpose for rights is to, sorry, are you saying something? It's muted. But as a Second Amendment right, and violation of the Second Amendment, I strongly oppose SB 301.
Your 2 minutes are up. If you can hang around for questions, people may have questions for you. Thank you. Next up is Church of the Crossroads.
Good morning.
Morning.
I'm Ellen Godby Carson on behalf of Church of the Crossroads. We're in strong support of SB 301. The Church of the Crossroads is a just peace church. It was Hawaii's first intentionally interethnic church. We have about 190 members who have voted unanimously to support a ban on assault weapons, to include the assault rifles and large capacity magazines that are subject to the hearing today. Hawaii is indeed the only state in the nation with an assault weapons ban that fails to ban assault rifles, assault shotguns, and the large capacity magazines for those weapons. In 1991, we did ban assault pistols and revolvers, and we banned the detachable large capacity magazines for those pistols. However, we left gaping holes by not banning assault rifles and large capacity magazines for assault rifles. So come to 1994, a few years later, Congress did enact the federal assault weapons ban, and that banned these types of weapons, and yet it sunsetted in 2004, and because of political impasse, it's not been able yet to be reenacted. In the meantime, these weapons have proliferated in our islands. An assault weapons ban that fails to ban assault rifles and large capacity magazines for them makes no sense. It is dangerous. It unnecessarily exposes all of us to a level of violence that we hope never to see. We're inviting needless risk of mass violence as we watch the national videos of persons with assault weapons threatening to disrupt our peace, our communities, and even our most august governmental bodies. These weapons are designed to be capable of mass violence. Their potential for mass murder far outweighs any plausible use for hunting, for sports, for recreation. The US now sadly has more mass shootings each year than there are days in the year, and Hawaii has not been immune. We can and should expand our own assault weapons ban to fill this void.
Okay. Thank you very much. The 2 minutes is over. Thank you for being here this morning. Next is Jerry Ewan for Pu'uloa Rifle and Pistol Club. I thought I saw him. Oh, there you are. Go ahead. Morning.
Hello, can you hear me?
Yes.
Yes, I'm Jerry Ewan, president of the Hawaii Pu'uloa Rifle and Pistol Club. I also served as the National Guard Range and Ammunition Manager. And prior to that, I was a United States Marine. In 1986, when the Marines first developed and implemented the M16A2 and the M9 pistol. They specifically sent me to school to learn and teach techniques. While in the National Guard in 1987 or 1997, I was sent to the Small Arms Instructor and Range Operators course specifically to teach and run ranges and marksmanship. Much of this law is, I would say, detrimental to military training. The Full Rifle and Pistol Club, we train primarily with AR-15 weapons. We also invite military come down with their M16 or M4 weapons. We practice from 200 to 600 yards in accordance with what we call the Civilian Marksmanship Program. This program specifically was to teach all U.S. citizens how to use rifles and pistols in case of an actual emergency or armed conflict where we would have to draft people, bring them into the military, and marksmanship is one of the hardest things to teach. And it's getting harder now that we don't have access to the same style of weapons. Marksmanship, a lot of it depends on getting familiar with that weapon to the point where it becomes a second nature. How Hawaii does overall on the marksmanship circuit, and I've worked with Todd Yukutake, actually sent them off to
Thank you very much. I appreciate your being here and testifying. Next up is Devin Sasai for Bushido Arms and Ammunition LLC. I think I saw you there. Yep, go ahead. You're muted still. Okay, there you go.
Hi, good morning, Chairman Rhodes, Vice Chairman, and members of the committee. My name is Dennis Sai. I'm testifying on behalf of myself and Bushido Arms and Ammunition LLC. I just want to reiterate my testimony that basically this is a feel-good measure that basically bans features of certain firearms that can drastically reduce the safety and function of a firearm. Case in point, reading my testimony, I highlight one of my friends who is disabled with only one arm, as well as my wife who is under 5 feet tall, to use stocks and grips to actually assist them in handling a firearm safely. I am also a firearms instructor that has instructed many hundreds of people, but I'm using the rest of my time to basically focus on the actually magazine portion of the bill. 2020 saw an influx of 7 million new firearms owners because of the pandemic, riots, lack of police response, and I believe the chairman actually in an interview recently with KITV asked a question, which was, are you really going to fire 60 shots in the middle of the night, defending your home when somebody tries to break in? So as an instructor, I will actually pose an answer to the chairman's question, which is, how much is enough? Okay, it's basically the biggest crime we're seeing right now is home invasion right now, and which is 2 or more people coming to the house. If we limit people to 10 rounds may not be enough. It may be enough. We really don't know. So to put an actual static number is actually counterproductive to home defense. Would you actually tell people, you know what, you can't have this car because it has this feature. You can't use an adjustable stock, an adjustable seat in your car to fit the person's needs. Guns are like cars in that we customize them to fit the individual person's needs. Same like magazines, we can't really determine what an individual person needs. That's their responsibility to do. So I implore the committee to please defer this opposition. Thank you.
Thank you very much. Next up is Kainoa Kaku with the Hawaii Rifle Association.
Hi, Senator. They're not present.
Not present. In opposition, Daniel Reed for the National Rifle Association. Oh, there you are. I can't see you, but okay. And I can't hear you now. Okay,
yes.
There you go.
Mr. Chair, members of the committee, for the record, Dan Reed, Western Regional Director with the National Rifle Association. We're here in strong opposition to SB 301. In an effort to not repeat testimony, we will stand on the written testimony that we submitted and just highlight that this ban really targets law-abiding citizens going after lawfully possessed, commonly owned firearms, rifles, shotguns, as well as magazines that are in lawful possession. This flies in the face of the Constitution. There is some litigation out there that was mentioned before, as well as the Ninth Circuit decision in Duncan v. Becerra on magazines capable of holding more than 10 rounds. It was ruled unconstitutional. I'll stand around for any questions. Thank you.
Thank you very much. Next is Marcus Tanaka. There you go.
Hello, thanks for having me. Morning. So I stand by my testimony and what others says to oppose this bill, but I wanted to add in, which I didn't do earlier, is I'm on the FBI website right now. It says murder victims by rifles. In 2019, there was 364 murders with all rifles. This is semi-automatic rifles, which this bill wants to ban. Any kind of bolt action rifle, any kind of rifle. 364 murdered in 2019, nationwide. 305 in 2018, 389 in 2017, 300 in 2016, 215 in 2015. So you see where I'm going with this. Average is maybe like low 300s, mid, at the most mid 300 average a year nationwide. So you guys are looking to ban something that there isn't a huge reason to ban it by the semi-automatic rifles. And the next thing was there was a bill SB 307 that wanted to ban 50 caliber or larger ammunition because reasoning was it can shoot at 1.5 miles. Well, a lot of bullets can reach that distance. You just have to know geometry. You got the curve. You have to factor in other things, and that's a very difficult to do. So SB 307 will ban 50 caliber larger rifles. It also bans shotguns. Then we have this bill that bans semi-automatic rifles. See how we're banning everything? So is handguns going to be next year? Or we're going to try this again? And my wife couldn't be here on the call, but she wanted to let you guys know that she wrestled in high school. She wrestled against males. So she knows the strength of a male who's not even looking to harm her, because wrestling, you're not looking to harm, you're just looking to beat the opponent. She had to wrestle males. She is most comfortable with her semi-automatic rifle that you guys are looking to ban. And to have a magazine with less than 10 bullets, she may need more than 10 bullets if there's more than one intruder looking to do her harm. And she still has to follow the Hawai'i use of deadly force law as well. So she cannot just open fire on someone holding a TV, because her life is not in danger if someone's holding a TV, but someone's trying to rape her.
Thank you very much.
Okay, thank you.
Next up is Dan Gu. I see you there. Go ahead.
Thank you, senators, for allowing us to testify. I'm a retired HPD detective, currently work for the U.S. Marshal Service, and I'm a hunter ed instructor. We oppose this bill. My family and I have been firearm owners for 3 generations. My father used to order firearms from the Sears catalog, and they used to mail it to his house. My wife sitting here next to me is a avid hunter, and the firearms that you will ban in this bill will not allow her to go hunting anymore. My wife just told me recently, she said, if a fisherman using a spear, would you take away his spear if somebody else used a spear to hurt somebody else? The answer would be no. I was bullied in high school, and I've been a victim of several crimes, burglaries and whatnot. And as a young child, I said, I'm going to be a policeman. I'm going to help my community. I'm going to serve my country. I'm going to protect people. Shortly after joining the police department in 1981, in less than a year, I realized I could not help anyone. I always got there after the fact, and I was a report taker. Then I realized that we need to protect ourselves, and we have to learn how to use firearms to be able to protect ourselves, because the police cannot get there on time. Another thing about the Church of the Lady Crossroads use Christianity. My wife and I are Christians, and we like to go hunting, and people in our church like to go hunting, use firearms for self-protection and for sport. So we strongly oppose this bill. It's about educating. It's not about more laws. I kindly ask Chair Rhodes that he defer this bill until we can meet in person and have a discussion on better ways to prevent crime, educating people versus creating more laws. So we oppose this bill, my entire family.
Okay.
And thank you very much.
Thank you very much. Next up is Michael Elliott, who I think, yep, there you are. You're still muted.
Yep.
There you go.
Okay, good morning, Senators. I am in strong opposition to this bill. Once again, we're seeing an attack and affront to the Second Amendment, where this bill attacks what is so-called assault weapons. That was a term created by the Democrats to describe what they thought were bad guns. It's describing function and feature, which is a complete misnomer. Also, these weapons are in common use. The Heller case and the late Justice Scalia and Justice Thomas spoke in great detail about this. And also the magazines that you're talking about are standard magazines. They are not high capacity magazines. They are standard magazines that come with these weapons and are in use with these weapons. Just yesterday, our daughter, who's in college to become a doctor, she's going to medical school back in Georgia. Her neighborhood, multiple vehicles and multiple homes were broken into by numerous intruders in her neighborhood. She has a firearm, which we work to get for her to help train her and everything. And it has high capacity magazines with that firearm for the sole purpose of protecting herself. She's 5 foot tall. She's 100 pounds. It is a great equalizer. And an AR style weapon is a great equalizer. There are numerous cases over the past couple of years where multiple home invasions, multiple individuals being deterred or being able to fight back against the intruders, sometimes where women, men, even teenagers who were able to.
Let me interrupt for just a second. The clock is malfunctioning. You're getting way more than 2 minutes, so that's fine.
Okay.
Finish out.
I'm in strong opposition.
Keep going. Keep going is fine, but for future testifiers, don't expect to get more than 2 minutes. Go ahead.
No, but I appreciate this opportunity. And once again, this is a front to the Second Amendment, and the registration process here in the state of Hawaii serves only to aid in potential confiscation if a bill like this were to pass. Thank you.
Thank you very much. Next is Ruben Betts. Ruben Betts.
Hey, Senator Rhodes, I have a list. Ruben Betts is not present.
Not okay.
Eric Ako is not present.
Hang on.
Justin Lee Solomon is not present.
Okay, they're all all those
Weber
are
is not
opposed.
present.
He's opposed. Michael Rice, I see. Go ahead. Morning.
Aloha. Basically, I'm against this law because it will ban pretty much all semi-automatic rifles, just of how vaguely worded it is. This is a Ruger 1022. This is quite often the first firearm an American will own. It's very simple. Obviously, this isn't a big, scary assault rifle, but just one provision on that list, one feature, a handguard will make it illegal. Because in there it says, barrel shroud that prevents the hand from burning from rapid fire. Well, a barrel gets hot after like 2 or 3 rounds, no matter how fast you're firing. So this bill will in essence ban all semi-automatic rifles, because I can't think of one that doesn't have some kind of safety grip or position to hold a rifle that would prevent your hand from burning. And on the other hand, California's been fighting bills exactly like this for a long time. If you look at California compliant rifles, you have AR-15s that are still legal even under these laws. What do? They put a fixed stock. They remove the pistol grip, put a different kind of grip on that still makes it usable. Well, in this case, you want to ban everything, so this entire handguard will have to come off. But hey, I can hold it like this. I don't need that handguard, and I can just grind down that bayonet. This little piece of metal right here, that's a bayonet lug. All right, and on the other hand, I have this rifle, which is an actual combat rifle. The AR-15 never was. This has bayonet. This has grenade launcher, which is this thing right here. And it doesn't have a pistol grip or a telescopic sight, but I could easily add those on. And you know what? This will not be banned under this bill because the magazine is not detachable. This is a fixed magazine.
Okay, thank you very much. Next up is Ellen Godby Carson, who's already testified, so she was in support, but let's move on to the next person, Micah Tanawai.
Yes, Senator, they're not present.
Not present. They're opposed. Derek Wong. There you are. Go ahead. Morning.
Good morning, Mr. Chairman, Mr. Vice Chairman, members of the committee. You all have my testimony. I'm not going to rehash that. I just want to add a little bit to this. As basically testified by that Church of the Crossroads lady, this bill is basically a knee-jerk reaction to what's been going on to the mainland, what we see on the mainland, and assuming that it's going to come here. We instantly react and try to ban something because we see that on the mainland. However, we're not thinking it through. You're basically trying to say we need to take away the instrumentalities of what can be used as a crime. We're taking away the gun, therefore it can't be used as a crime. But following that exact same logic, we need to ban kitchen knives, bats, cars, pipes, anything that can be used as a weapon should be banned under this rationale. That same rationale that she talks about and that rationale that this bill is talking about, all those instrumentalities that can be used as a crime should be banned. That's not case in point. Second Amendment protects this one right. It's a constitutionally protected right. It's already talked about those things, features shouldn't be, they can easily be removed and you still have a weapon. As far as the magazines are concerned, once again, there's a case that in the Ninth Circuit, which we sit in, that has basically said that it is unconstitutional to have a blanket ban on high capacity rounds, which means if this passes, it's going to be defeated at the Ninth Circuit. Cert was denied in that case, which means if you pass this bill, you know very well that it's going to die in the Ninth Circuit, and the taxpayer, me as a taxpayer, has to pay for the defense of that bill. Other than that, I do strongly oppose this bill. I am not speaking on behalf of the military. I speak on behalf of myself as a private citizen. This bill, once again, is a front of our rights and should not be passed at this time as written. And I leave that with, I'll be available for questions at this point.
Thank you very much. Next is Ryan. I'm sorry, I don't know how to pronounce your last name. Ryan Tina Jero or Hero or Yarrow. There you are. Go ahead. Good morning.
Good morning, sir. Senators of the Judiciary Committee, thank you for the opportunity to testify. I stand in my written testimony in opposition to SB 301 relating to firearms, and I'll address just the prescient points. Contrary to the measure's introduction, the measure is actually inconsistent with the legislature's commitment to the safety and well-being of Hawaii citizens. I already outlined most of the points in my testimony, but when you look at the objective data points from the Centers for Disease Control and Prevention for the state of Hawaii, firearms pales in comparison to the rest of the real causes of health and safety issues to Hawaii residents. Leading cause of death, as indicated by the key health indicators on the CDC website, is heart disease. Next runner-up after that, drug overdose death, with a death rate of 14.3 per 100,000 total population. Firearms does show up with a single digit 4.0 deaths per 100,000 total population. And then an important one, homicide rate with 3.1 deaths per 100,000 total population. That one's important because that involves the death of a person without the requirement of firearms. On that same website, you scroll down to leading causes of death. We have the number one leading cause of death, heart disease, followed by cancer, and the list goes on all the way down to Parkinson's disease, but it doesn't address firearms. Firearms doesn't even make that top 10. You could focus your efforts on COVID-19 relief because, as you stated earlier in the last testimony, Chairman Rhodes, we are in a pandemic now. Accordingly, the people of Hawaii need help now. That can be achieved by focusing your efforts on Senate Bill number 266 and draft 1, which your standing committee in report number 135 already emphasized the encouragement of further discussion. I'm happy to answer any questions. Thank you for your time.
Thank you. Next up is Will Cockett.
Hi, Senator, they're not present.
He's opposed. Justin Province.
I am present.
Oh, you are. Okay. Can't see you. There you go. Morning.
Good morning. I'd like to thank you all for having me here today, and I'd like to open with an amendment from our Constitution. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. The recent attack on our constitutional rights, both state and nationwide, is absurd and is a disgrace to our culture and our ancestors. I'm here today as a law-abiding citizen of Hawaii with the hopes of becoming a legal firearm owner as I turn 21 at the end of this month. Furthermore, I intend to help prevent any measures from passing that will remove our rights to firearm ownership. I come representing the next generation of Hawaii, like myself, who would like to practice and protect our Second Amendment. I'm here today in strong opposition of unconstitutional bill SB 301. SB 301 is ending a cornerstone to the Second Amendment right to bear arms within our state. I've come to testify that SB 301 shows complete disrespect to the people of this great nation, to the Constitution and the Second Amendment. The founding fathers who risked life and limb to found this country recognized the necessity of the people having the right to bear arms as a crucial piece to our democracy. A ban, restriction, or tax on any weapon, part, or caliber is unconstitutional and restricts us from our life, liberty, and the pursuit of happiness. Finally, a ban on these firearms only incriminates law-abiding citizens of Hawaii. It also sends a negative message from the state on how it respects our constitutional and natural rights. When a law is introduced or passed, it is supposed to be for the people, of the people, by the people, protecting their life and freedoms, as well as granting them security and liberty by helping to ensure our collective safety and freedom to live as we choose. Suggested bills and or laws should not be incriminating, disarming, or destabilizing the American people, and laws like this do not speak for me, nor does it have the benefit of the public in mind. As it clearly states, in God we trust on the American dollar bill, for they knew then and now that the right to bear arms was endowed to us by our Creator, undeniable and inalienable, and it shall not be infringed.
Okay, thank you very much. Next up is Raymond Michaels.
Hi, Senator. They're not present.
He's in opposition. Michael Botello.
Aloha.
Oh,
Thank you, Senator. My name is Michael Botello of Kaneohe. I am a former submariner and a Navy diver, and I'm here to testify in my capacity as a private citizen, and I am in strong opposition to SB 301. We are all created in the image of God, and therefore have the right to life and the means to provide for and defend our lives against anything that would threaten it. This applies to self-defense as well as the security of a free state. This bill is a direct attack on these natural rights and places today's generation at the mercy of robbers and thieves while denying future generations the ability to defend themselves. The founders of this country enumerated the Bill of Rights and the Second Amendment specifically, precisely to deny legislators the ability to challenge these principles and change the way we live our daily lives. If this bill isn't stopped now, it will only lead to additional rights being taken away until we don't even have the legal authority to carry knives on our persons the same way they've done in London, England, because there's never a reason to carry a knife. A local resident doesn't have to look very far to see the increase in violent crimes, with a new headline popping up just this morning about a person arrested for a string of aggressive robberies, including tying up a 76-year-old woman. The senators should be spending their time finding ways to support a person's right to self-defense instead of denying them that right. The passage of this bill will only endanger the people of this state and will not make them any safer. For these and many more reasons, I strongly oppose SB 301. Thank you.
Thank you. Next, we have Davin Asato. I see it.
Hi,
go ahead.
Good morning. Good morning. My name is Davin Asato. I'm a resident of Kahalui, Maui. Thanks to COVID-19, I have the opportunity to come before you and oppose SB 301. I am an assistant pastor for a local church, and we are constantly looking for ways to protect ourselves due to mass shootings that are happening in the mainland churches. The bill and wording of SB 301 would greatly inhibit that and the ability to be able to effectively protect our congregation and ourselves in our own homes. The magazine ban that's also included in this bill, it would be very difficult to enforce on the private population. And for those that would actually look to be in compliance with that law, if they were taking their magazines in to have it blocked, and unfortunately were stopped for a taillight that was out that they were unaware of, they would also be in violation of that law immediately upon its passing, even though they're in an attempt to do the right thing. And so the immediate passing of this law would turn many law-abiding citizens into criminals immediately. In addition to that, with the ban of many commonly used firearms, of the features for semi-automatic weapons, would then turn these law-abiding citizens again into felons overnight. We strongly oppose the passing of SB 301. I am available for questions, and will direct one more thing. I'm sorry. In my testimony, there was a situation of my police department engaging a single suspect who had a handgun. He fired approximately 9 shots at police officers, at 3 police officers. Our officers here have 13 round capacities in their handguns. They fired approximately 40 rounds between the 3 of them, striking him only 12 times.
Okay, thank you very much. That is all the testimony that we have, in-person testimony that we have. I already mentioned before the voluminous testimony that we received, so I'm not going to bother to go read everybody's name. So at this point, members, questions?
I have a question.
Senator Favela, go ahead.
We had a lot of testifiers. So the ones that do training or rifle or gun training, or have participate in doing so. And we have one of them that do, I know I had a couple of the instructors that do training. Can we have them come on?
I don't remember which one that was. So yes, go ahead. Jerry Ewan, Devin.
Any of them still on? Todd, are you on? Okay.
Hello, this is Jerry Ewan.
Okay, hi. Who's in this talking? Trying to see. Jerry?
Yeah,
you?
Jerry.
Okay. The reason why I'm asking this question, I'm not sure of how much of my colleagues went through the training, but when you do the training, whether it's female or male, first time touching maybe a rifle or a pistol, how difficult it is for them to even get used to holding the weapon?
The question was how difficult it is to get used to a weapon.
People come in for training or getting to buy a weapon, because you got to go through some kind of training, especially for your pistol. When they first come to do the testing and go through the permitting process and all of the whole shebang, because Hawaii has the strictest regulations. So my question is, when they do all of these paperwork, when they decide to go and purchase either a rifle or a pistol, a handgun, how difficult it is for these new gun owners to get used to even properly holding.
Yes, it's very difficult. Part of it is trying to find qualified instructors to actually teach them. Getting range time is also difficult because of the pandemic. Range capacity is reduced in half. Also because of the pandemic, ammunition is hard to find. Gun stores are all bought out of common calibers like 22 long rifle, 9mm, 223 Remington, also known as 5.5 Sato. But there is a demand for training.
Yes.
There is a demand for training. A lot of it is.
Yeah, thank you, Jerry. No, the reason why I bring that up is because I know some of the people are not only waiting for training, they're also waiting for getting their permits at HPD, and it's up to 6 months. 6 months backed up at HPD for getting this. And the reason why I'm bringing this up, me as a 6 feet, 300-pound male, had a very difficult time when I went through the training because I wanted to learn what was the process. And having 10 rounds in the pistol, which the law had passed, is very difficult. And you guys just heard, not even law enforcement that train a lot that hit the target. So we understand that you guys had put a ban, we ban on 10 rounds. But like the previous speaker said, I guess Jerry or Todd, most of these rifles come already with a magazine with more than 10 rounds, right?
That is correct. A standard capacity is 30 rounds.
Yeah. And the next question that I want to ask is that when I was 9 years old, my dad bought a rifle from, I don't know if you guys remember, Hansbot. It was a 12-gauge double-barrel shotgun, and it says Sears on it. Yeah, it's a very difficult to have the thing transferred to ownership in the day that God calls my dad home. But this gun that we're talking about that had been bought when I was 9 years old will be banned under this law. Any of you guys thought, is that correct?
It could be, yeah. This bill pretty much, like one of the testifiers said, most rifles have a handguard on it. So pretty much any semi-auto rifle with the magazine will be banned. Even like M1 carbines, that's a World War II rifle that a lot of pig hunters use in Hawaii. That would be banned too under this law.
Yeah, because the reason why I'm bringing this up is because when you hold, I'm not saying I hold them, but when I was young and I see my dad hold them, he has that grip in front of the barrel. I want to tell you guys right now, I don't know if anybody shot a 12-gauge shotgun, and my dad is a pretty big guy too. If he doesn't have that grip, there's no way he can hold that rifle with one hand. So that's just my comment. I just want to see if you
Senator Favela, can I
understand it. Thank you guys.
I'll come back to you if you like, but let me see if other people have questions. Any other questions, members?
That's what I said. Thank you, Chair.
Thanks. Okay, no other questions. All right, Senator Favela, do you have more questions? Okay, if there are no more questions, I'm sorry. Hang on a second. Senator Ocasio, and then I'll go back to Senator.
Go ahead.
I'm not quite sure if someone is on that can answer, but does this also ban this kind of assault rifles, et cetera, from current HPD or law enforcement, or it's only to the public?
It seems that the way that it is currently written, it doesn't have exceptions to law enforcement or military.
Okay, that's what I thought.
HPD actually wrote in their testimony about that there is no provision, and Maui police actually opposed this bill as well in their testimony.
That's not entirely accurate, but no, there's already an exception for work-related guns. It's already in law that's not affected by this. There was a request by HPD and by Maui to have a carve out for officers who own the weapon individually, but use it at work. But it doesn't. But this bill does not affect the general carve out for work-related uses for weapons. Do you have more questions, Senator Ocasio, or were there? I'll go back to Senator Favela then. Go ahead.
Chair, thank you for the opportunity. I just want, like I said, any of these guys answer the question. We know the pandemic part and the 22 rounds and a lot of bullets are out. Since this kind of bills that have been coming up, I've been very curious and been going around and asking questions. But I wanted to know if I understand law enforcement have to, because the HPD and Maui police, but you guys have a lot of these customers come to you guys' range or to you guys' store, how do they really feel? Because I know, because I talked to a few of them, how do they really feel about this ban? Because we are law-abiding citizens, and they would rather have a law-abiding citizen watch their back that bought the gun illegally and trained on it hard when the range is there. How much of them come into your store with very mixed feelings and troubled of being a law enforcement person?
Senator, let me try and answer that as an actual gun dealer manufacturer. The pandemic really kind of threw everybody for a loop, which is why we have 7+ million new gun owners this year. That being said, a ban like this drastically limits a citizen's, ability to protect themselves. Again, I said this in my testimony earlier. It's like having a car. You buy a car with features to fit your needs. You also buy a firearm with features to fit your needs. Again, my friend is disabled, doesn't have an arm. My wife is 4'11". You cannot expect my wife or my friend to use the same firearm as me for defensive purposes. You have to find one that's going to fit them properly. So this bill, by eliminating certain features or categorizing certain features to make it prohibitive to somebody, would drastically reduce their ability to protect themselves or the community at large. Same with the magazines. Again, how do you know how many rounds is enough? If you have 1 assailant, 2 assailant, 5 assailants, we've seen this in Seattle, Portland, New York, Kenosha. We've seen these riots around the country. Luckily, it never happened here, but it doesn't mean that it will never happen here. Okay, so again, it comes down to what an individual feels is necessary for themselves, and that's the pretty much consensus among all customers.
Okay, thank
Thank you.
Members, any other questions? I don't see any other questions from members. Okay, let's go ahead and.
Chair, I have a question.
Oh, Senator,
and I think maybe for Mr. Sasai, off of the statement he just made. In your mind, Mr. Sasai, would there be a deviation in the way a shooter would configure or in their mind proceed to configure a weapon to execute a mass casualty event versus an individual citizen in their approach to configure or approach how they would configure a weapon to protect themselves or their property in the event of a riot down the street?
Sure. Okay. So as we saw in Las Vegas, Las Vegas shooting, right? The shooter in that case actually used a bump fire stock, allegedly. So as we know in the state of Hawaii, HRS has already banned bump stocks. So again, the ability for, say, a potential mass casualty event to happen, like Las Vegas, has already kind of been taken off the table when it comes to that. A firearm is a tool, Senator. It's no different than a hammer or a screwdriver. It's what the person does with it that will actually determine whether it's good or evil. So is there a way for a person to configure a firearm to inflict more casualties? The straight answer is really no. You're gonna configure the firearm to your individual needs, but there is a limitation. Perfect example is that if you want to conceal the firearms, conceal the rifle, you would need a barrel length that's, say, maybe 10 inches or 9 inches, which again is banned in the state of Hawaii as it is. It's part of the National Firearms Act. It will be considered a short barrel rifle. You can't have that in the state of Hawaii. So again, the person who wants to do a mass casualty would not be able to conceal it. They would not be able to get a barrel length of, say, 9 or 10 inches. It would have to be 16 inches or longer. It would not be concealable. If you had say an AK-47 with a folding stock, a traditional one, folded up and trying to be concealable, it would be under 26 inches long, which would actually put it again in the NFA. It would be restricted to a federal tax stamp of $200 in a different state. The state of Hawaii is a non-NFA state. We cannot have suppressors, short barrel rifles, short barrel shotguns. The features that you're probably looking at to, I guess, enable a person to do a mass casualty is not available in the state of Hawaii. That's the best answer I can give you.
Is there, to your knowledge, and I guess I can throw it out to any of the other members who are still on the conference, with indulgence of the chair, is there any data to indicate, aside from bump stocks and some of these other features that have been previously banned because of their usage in a mass casualty event, is there any data to indicate the prevalence of certain types of configurations for use in mass casualty events, as opposed to configurations for the protection of self and property, you know, in the event of the type of riots and things that have been mentioned in the testimony to justify opposition to the, you know, among other reasons for opposition to the bill?
Sure. Actually, the actual data shows that the majority of mass shootings are done with handguns, not the rifles or shotguns that are in question with this bill, or the magazines. They are done majority.
Well, so I'm not asking about because then you get into a debate over the sufficiency of the data. Then you end up in an academic argument. I'm asking about data that relates to the correlation between the utilization or the configuration of certain types of weapon features in the execution of mass casualty events, as opposed to the utilization and configuration of certain weapon features for home protection.
No, there is, as far as I know, I don't believe there is that.
Okay, thank you. Thank you, Chair.
Mr. Chair.
Thank you.
Mr. Chair.
Senator Kim, go ahead.
Are we going to go into decision making, because I'm going to have to be leaving, so.
Yeah, we have a hard stop at 11. I didn't want to cut off debate. We'll just roll over to another day if we don't get done. But did you have a question?
No, I don't. Thank you.
Okay. Senator Lee, was there a question there?
Just following up on Senator Kyohokololi's questions, I guess back to Mr. Sasai. I'll try to be brief, Chair. Thank you. I appreciate your comments about what sorts of particulars with respect to one particular weapon may make it more suitable for someone defending themselves versus going out. Now, I do think it's pretty clear, just looking at the data. Obviously, if you want to go out and commit a mass shooting where there's a lot of people, you're going to need some range generally, which is why Las Vegas shooting, you know, most of them have been using some sort of variant of a rifle of sorts like this that are being discussed today, with some of the features here and there depending on the particular shooting. Whereas most of the self-defense situations, I think that you said, are indeed mostly handguns, generally speaking, as are most of the deaths around the country, excepting mass shootings. And so I guess what I'm getting at is, one, you know, I think the point you made is a valid one. What features in a gun make it most useful for different people? I think you had mentioned people who had particular disabilities and other sorts of things like that. I think we can all agree. But you also made the point that Hawaii currently bans certain features like shorter submachine gun configurations, things like that, which would definitely be a lot more helpful for people to be able to carry something that's a lot lighter, which still has a significant amount of capacity to discharge. And so I guess what I'm getting at is, setting aside all the particulars that have been discussed about, is it this type of grip, is it this type of whatever? I mean, just generally speaking, are we having a discussion here about opening up the existing law to allow submachine guns and other things like that in those configurations, because the premise, or I guess the primary point that you're trying to make, is it should be comfortable, it should be usable, maybe it gives you more control, maybe less, depending on the situation? I guess, is that the primary driver, or are there other considerations to be had?
Senator, I don't believe, as much as I would like to get into this with you, I don't think Chairman Rose or anybody else wants to really drag this on longer. So I'll just answer the questions directly, which is I'm focusing on this bill in particular. We can bring up short barrel rifles, short barrel shotguns at a later date, but I'm looking at this bill in just particular. And actually, just to correct, actually it was the reverse. Mass shootings are done majority with handguns and not rifles. Whereas a rifle in a home can actually be a very effective defensive weapon. But again, to answer your question, no, that is not my primary driver today. My primary driver today is to give the committee all the information that I can give them as far as what these features do. Like, flash fire does not enhance lethality. Neither does a stop. Neither does a thumb hole stop. Neither does a shroud. None of that stuff enhances the ability or makes it more lethal to your point in a mass shooting. None of that does. Again, a rifle is just a tool. It's what the person does with it. Now, whether they choose it, if they can't get a rifle, they'll get a handgun. If they can't get any guns, they may use a knife. They may use a car. They may use a bomb, God forbid. Okay? But basically, ill intentions have no intentions. And regardless of the tool, don't persecute the law-abiding citizen. The people that are going to follow the law. Something that somebody might. And that's just the basic thing. Again, we can discuss it at a later date as far as the usefulness of, say, short barrel rifles. But I don't think that is today is the place for that.
I appreciate the engagement on this. I think we can agree to disagree on some of the data, and perhaps, obviously, this isn't the particular place to be rolling out all the facts and figures with numbers and whatnot. I'm sure that'll be reserved for debate on the floor, should this bill proceed, and many other things. So, Chair, in the interest of time, appreciate it. Thank you very much.
Okay, thank you. Members, any other questions? Okay, if not, I'd like to go ahead and do decision-making on some of the less complicated and controversial bills, but I'm going to defer a couple of them until next week. And so I think we can go through most of them without too much disagreement, and then we'll deal with the others next week. So starting out with SB 630, this establishes that every judgment for child support is enforceable until paid in full. Recommendation on this one is to pass with amendments. I'd like to accept the Attorney General's amendment. It's basically technical in nature, just being sure that the sections work together. Questions or concerns on SB 630? If not, Senator Keokalole.
Members voting on SB 630, the chair's recommendation is to pass with amendments. Chair Rhodes.
Aye.
Vice Chair goes aye. Senator Ocasio.
Reservations.
Senator Gabbard.
Aye.
Senator Kim.
Aye.
Senator Lee.
Aye.
Senator Favela.
Reservations.
Chair, your recommendation is adopted.
Thank you. Next up is SB 639. This prohibits courts of appeal from affirming, modifying, reversing, or vacating a matter on grounds other than those raised by the parties to the proceeding, unless the parties are provided the opportunity to brief the court and present oral argument. Recommendation is to go ahead and move it forward with an amendment. The amendment suggested by the Attorney General to allow the parties to supply a brief, but we would not require the courts to allow an oral argument. Questions or concerns? If not, Vice Chair.
Chair, I think I see a question.
Oh, I'm sorry, Senator Ocasio.
Chair, so does that amendment address the issue of fairness that the judiciary raised in their testimony?
Well, they really objected to raising. Well, yes and no. They don't like the fact that they would not be able to sua sponte, meaning on their own initiative, throw things out that were, I forget the technical term, but obvious error or something like that. This would require them to at least get briefs on whether the error was really all that obvious. So they'll like it better, but they still won't like it, if that makes sense.
Okay, thank you.
Any other questions? If not, Senator Keokalole.
Members voting on SB 639, the chair's recommendation is to pass with amendments. Noting the presence of all members, is there any opposition? Are there any reservations?
Reservations.
Reservations for Senator Ocasio. Any other members with reservations or opposition? Seeing none, Chair, all other members vote aye. Recommendation adopted.
Okay, thank you. Next up is SB 714, clarifies the rights of publicity, clarifies that the rights of publicity includes the rights of individuals who died prior to the enactment of the Hawaii Publicity Rights Act. Recommendation here is to pass with just technical amendments. Questions or concerns? Seeing none, Vice Chair.
Members voting on SB 714, Chair's recommendation is to pass with amendments, noting all members present. Any reservation? Any opposition? Seeing none, Chair, all members vote aye. Recommendation adopted.
Thank you. Next up is SB 834. This establishes the felony offense of importation, sale, or possession of a childlike sex doll. Recommendation here is to pass with amendments, accepting the language from the Honolulu prosecutors to make the language consistent with other statutes. So it's basically technical, but that's it. Questions or concerns? If not, Vice Chair.
Members voting on SB 834, the recommendation is to pass with amendments. Noting the presence of all members, are there any reservations? Any opposition? Seeing none, Chair, all members vote aye. Recommendation adopted.
Thank you very much. Next up is SB 873. This authorizes contested case hearings to use interactive conference technology. Recommendation here is to go ahead and pass with some amendments. Broaden the method of delivery of evidence to electronic means so that it's not too specific, and change the language that requires the physical location of all parties and their counsel to be on the notice to having the electronic contact information for each party and their counsel to be on notice. So that, yeah, sorry, I'll repeat that. Change the language that requires the physical location of all parties and their counsel to be on the notice to having the electronic contact information for each party and their counsel to be on notice. And I'm not quite sure we're there with this bill, so I'm going to put a bad date on it too, May 6, 2137. Questions or concerns? If not, Vice Chair.
Members voting on SB 873, the Chair's recommendation is to pass with amendments, noting all members present. Any reservations?
Reservation.
Reservations for Senator Favela. Any other reservations or opposition?
Reservations.
Chair, we have reservations for Senators Ocasio and Favela. All other members vote aye. Recommendation adopted.
Okay, thank you very much. Next, we have SB 1034 relating to Sunshine Law boards. This would expand board and public participation by giving boards the option in conjunction with in-person meetings to use interactive conference technology to remotely conduct public meetings under the Sunshine Law, even when no emergency has been declared by government authorities. This is one of the complicated ones. I'm going to go ahead and just defer it until next week. Let me find my deferral date. We'll defer DM until Wednesday, February 17 at 9:55. Wednesday, February 17 at 9:55, and that will be by video conference. Finally, related to firearms, the bill that we talked about extensively today, limiting the size of the magazines to 10. This one I will also defer until that same time and place for decision making. Wednesday, February 17 at 9:55 a.m. and that will be by video conference. I believe that's it for this agenda. Thank you very much all. Thank you all for being here. Have a good day.